Keisha again Rotho Tim, Seryange Ignatius, and Odeke Ryan.
N'olwekyo Oweekitiibwa Omulamuzi akkanyiza ne ba assessor bamuwabula abagamba nti oludda olwabi luleese obujulizi obumala okulaga nti mu butuufu abaana bano Eteku, Keisha, Seryange ne Odeke baafa.
I will go to the last ingredient, and that is the ingredient of malice aforethought.
Kati agenda kwogera ku ky'okugamba nti eyatta abaana bano yali alina ekigendererwa.
Malice aforethought is defined in section 174 of the Penal Code Act. And the summary of it is that malice aforethought shall be deemed to be established by evidence provided for by the following circumstances. An intention to cause the death of any person, whether that person is the person actually killed or not. B, knowledge that the act or omission causing death will probably cause the death of some person, whether that person is the person actually killed or not, although the knowledge is accompanied by indifference, whether death is caused or not, or by a wish that it may not be caused. In summary, that you must have had an intention to kill somebody, or you had knowledge that your acts or your failure to act would actually result into the death of a person.
Ekigendererwa ekitabo ky'ebibonerezo akawayiro 174 kigamba nti obujulizi bulina okulaga nti wali olina ekigendererwa okutta omuntu n'oba nga ogose siku wali oyagala kutta, olina okubeera ng'omanyi nti bino byonna by'oli mu kukola biyinza okuviirako kufa kw'omuntu. Ekikulu kiri nti olina okuba ng'omanyi nti byonna by'ogenda okukola biyinza okuviirako omuntu okufa.
So malice aforethought is a mental element, and it is not easy to prove with direct evidence. But inferences may be made from a number of things, including the nature of the weapon used, the part of the body targeted, the nature of injuries, and the conduct of the accused person before, during, and after the commission of the offense.
Ekigendererwa kibeera mu mutwe gw'omuntu, n'olwekyo kiba kizibu nnyo okuleeta obujulizi okukiraga, naye basobola kukirabira ku bintu bingi. Ekisooka basobola kulabira ku kisi ekikozesebwa, basobola kulabira ku kitundu eky'omubiri kye bakozesa, era basobola kulabira ku biwundu oba obuvune omuntu bw'afunye, ate basobola kulabira ku nneeyisa y'omuwawaabirwa mu kukola ekintu ekyo ng'akikoze oba nga tannakikola.
Prior planning or prior threats of the accused may be used to infer malice aforethought.
Omuntu okusooka okuteekateeka ekintu basobola okukiraba ne bagamba nti yali alina ekigendererwa.
To prove this ingredient, the prosecution adduced evidence from eyewitnesses to the offense, that is Phoebe and Annette, who testified that they saw the accused person aggressively and gruesomely cut the necks of the 4 children with a knife.
Nti oludda olwabi lwaleeta obujulizi bw'abantu abaaliwo nga Annette ne Phoebe, era bajja ne bagamba nti baalaba omuwawaabirwa ng'asala bubi nnyo ensingo z'abaana bano.
This evidence was corroborated by the findings of the post-mortem examinations of the 4 children's bodies and by the testimony of Dr. Katongole Abdul, who examined all of them and described the injuries on the deceased as follows.
Era ekyo kyongereza ku bujulizi bwa postmortem reports oba ebbaluwa ripooti omusawo gwe bayita Katongole ze yawandiika ng'amaze kwekebejja emirambo gy'abaana bano n'annyonnyola ebiwundu abaana bye baafuna bwe tugenda okubyogera.
And I will go in the detail of the injuries for each of the deceased children. I begin with Eteku Gideon. He is said to have had a 14-centimeter long open wound on the right side of the neck, located at 66 centimeters from the right hem of the neck. The wound was longer than its depth, characterized by smooth edge, regular margins, no bridging fibers, marginal contusion, and the wound was deep, transecting through the esophagus, trachea, internal jugular vein, cut fractures, and the above descriptions were consistent with deep cut wounds.
Tusooka ne Eteku Gideon yalina ekiwundu obugazi nga kyali kya sentimita 14 ate nga kyali ku bulago side ya ddyo nga kyali kiwanvu nnyo nga kifumitira ddala ne kyonoona ebitundu ebisinga eby'obulago era nga kiraga nti baamusala nnyo.
Keisha Ageno wrote, Otim was said to have a 9-centimeter long open wound on the right side of the neck at 67 centimeters from the right hem and 1 centimeter from the anterior midline, and the wound was longer than it was deep.
Nti Keisha naye yali alina ekiwundu nga kyali kya bugazi sentimita 9 nti ate nakyo kyali ku bulago side ya ddyo nti kyali kiwanvu nnyo.
The wound was big, transecting through the skin, underlying neck muscles, the trachea, esophagus, major neck vessels, and nerves.
Ekiwundu kyali kiwanvu nnyo nga kiyita mu mubiri ne kisala emisuwa egisinga egy'obulago.
And he concluded, or he noted, that these findings were consistent with deep cut wounds.
Era n'agamba nti ebiwundu ebyo byaliwo olw'ensonga nti baamufumita nnyo.
Seriang Ignatius was said to have had a 14-centimeter long open wound on the right side of the neck, which was longer than it was deep.
Seriange naye yali alina ekiwundu nga kyali kya sentimita 14 ate nga bali bamusaze nnyo.
The wound was deep, transecting through the skin and underlying neck muscles, injuring the internal jugular vein.
Nti ekiwundu kyali kiwanvu nga kisala ne kiyingira ne kisayira ddala emisuwa gy'obulago.
He found that the above descriptions were consistent with deep cut injuries.
Era n'agamba nti ekiwundu kino kyajja olw'ensonga nti baamusala nnyo n'afuna obuvune.
This one also had another 4-centimeter long cut wound located on the right submandibular region. We go to Odeke Ryan, the last child. This one was said to have had a 9-centimeter long deep cut wound located on the right side of the neck. It was a deep cut wound dissecting through the underlying neck muscles, neck vessels, trachea, esophagus, and transection of a spinal cord. The cause of death for all the children was established to be hypovolemic shock due to cut wounds to the neck.
Odeke naye yali alina ekiwundu nga kyali kya sentimita 9 nga kirina ku kono y'obulago era ng'ekiwundu kino kyali kiwanvu nnyo nga kisalira ddala emisuwa egisinga egy'obulago nga kigendera ddala ku nkizi. N'agamba nti kyaviirako omwana ono okufa, baamusala nnyo n'avaamu omusaayi mungi.
All the postmortem reports for the 4 children were admitted and marked as exhibits 1, 2, 3, and 4 respectively.
Alipoota z'omusawo ze yakeberako abaana bano banna zonna baazireeta mu kooti ng'ebizibiti ekisooka ekyokubiri ekyokusatu n'ekyokuna.
This evidence is further corroborated by the evidence of the scene of crimes officer, Mr. Mutaka Jimmy, who visited the primary scene of crime. This is the center. Immediately after the commission of the crime, he processed it and made a report which was admitted as PEX 10. And this is what he said, that at the center, he found the body of an infant on the veranda, and it was identified to him as that of Okello'S. And he uniquely marked that body as 3. On this body, he observed one deep cut injury on the right side of the neck, with cuttings through the neck bones and muscles. And he took pictures of this body, and they are in his report on page 11 and 12.
Nti kino kyongerezebwako obujulizi bwa soko oba omupoliisi agenda mu bifo bye bazizaamu omusango bamuyita Mutaka Jimmy, era yagamba nti yagirawo mu kifo ekyo n'awandiika alipoota gye baleeta ng'ekizibiti ekyo-10. N'agamba bwe yatuuka mu kifo ekyo yasanga omulambo gw'omwana omuto eyali ku kabalaza nga bali bamuyita Ryan, n'aguteekako namba 3. N'agamba nti omulambo guno gwali gulina ekiwundu ekinene ku bulago, ng'ekiwundu kino kyali kisala amagumba n'emisuwa egy'obulago, era n'akuba ebifaananyi n'abiteeka mu alipoota eyo.
Shortly thereafter, he went to Wenzi Medical Center, this is the secondary scene, where he found the bodies of the 3 children, and they were identified to him as Eteku Gideon. He uniquely labeled his body number 32, Seriang Ignatius number 37, and Keisha Ageno Rotho team was labeled 39.
Omupoliisi oyo yayongera n'agenda ku Wenzi Medical Center. Bwe yatuukayo ne bamulaga emirambo gy'abaana abasatu, Eteku n'amuteekako namba 32, Seryange n'amuteekako namba 37, ne Keisha n'amuteekako namba 39.
PW 14, this is the scenes of crimes officer, further testified that all presented similar fresh injuries of deep cuts on the right side of the neck, which went through the muscles and bones.
N'agamba nti abaana bano baali balina ebiwundu nga byagala kufaanagana, nga bonna baali balina ebiwundu mu bulago ku ddyo, ate ng'ebiwundu bino byali bisalira ddala nga bisala n'amagumba n'emisiwa y'obulago.
This court also observed the photographs of the bodies of the 4 infants and confirmed the gruesomeness of the attack on all of them, as evidenced by the nature of the injuries.
Era kooti yatunuulira ebifaananyi by'abaana abo n'ekakasa engeri abaana gye baafaamu baafa bubi.
The murder weapon, which is a knife, which caused those grave and fatal injuries on the children, was also recovered at the primary scene of crime, just behind the chain link fence, after being thrown by the accused person, and it was also admitted as evidence.
Nti era n'ekisi akambe baakafuna nga baali baakasuula wabweru ya geeti ne bakaleeta mu kooti ng'ekizibiti.
So we have those grave injuries and the knife that caused them.
Tulina ebiwundu ebyali ebibe ennyo n'akambe akaakozesebwa.
The above evidence would be sufficient to prove malice aforethought, because there would be no other inference that a person pounces on defenseless, innocent babies and goes ahead to cut their necks as if slaughtering a goat or a chicken in that accurate and precise manner, other than that of malice aforethought.
Nti era ku bujulizi obwo bulina okuba nga bumala, kubanga omuntu tasobola kugenda n'akwata obwana obuto nga tebusobola n'abusala obulago ng'asala embuzi oba enkoko.
However, the defense heavily contested this ingredient and insisted that the accused person was not in a right state of mind to form an intention to commit the offense of murder.
Nti oludda olw'omuwawaabirwa balooya be bagamba nti ebyo si bituufu kubanga nti omuwawaabirwa omutwe gwe gwali tegukola bulungi n'olwekyo yali tasobola kutemula.
The accused person in his unsworn statement stated that he did not act intentionally or deliberately, and although there were claims that he was completely mentally okay, there may have been other mental challenges that may have gone undetected, which could have contributed to the death of the children. He insisted he was not mentally okay.
Nti bwe yali ayewozaako teyalayira naye n'agamba nti ye kino teyakikola mu bugenderere, n'agamba wadde nti bagamba nti omutwe gwe gwali gukola bulungi naye bayinza okubawo ebintu ebirala bye bataategeera ebiyinza okuba nga byamuviirako okukola ebyo bye yakola, n'akakatizza ensonga egamba nti ye omutwe gwe tegukola bulungi. Omutwe gwe gwali tegukola bulungi.
The accused also denied being foul-minded in the killing of the children, and in respect to this, he made reference to the book. I already talked about that, but this is for emphasis. That the flash disk which showed that he had done a search and saved a book on the art of war. He stated that this he did it long ago and it had nothing to do with the death of the children.
Nti era agamba nti ekino ekintu kyonna teyakiteekateeka ekyokutta abaana, n'agamba nti ekyokuteeka akatabo k'entalo n'okunoonyereza byonna bye yanoonyereza, agamba nti akatabo yakanoonyerezako ebiseera by'emabega nnyo tebiyinza okuba nga bye byamuviirako okutta abaana abo.
He also denied being deliberate and with forethought while making reference to the evidence of the Google searches that he made using his phone, specifically the search for ISIS beheading and for schools that teach young children. And he said that whereas these searches may suggest that he did it deliberately, there were other factors forcing him to make those searches, which factors he chose not to disclose to the court.
Nti era yagamba nti ye teyabikola mu bugenderere, era n'agamba nti bino bye yanoonyerezaako ku mukutu ng'ebya ISIS okuggyako emitwe, amasomero agasomesa abaana abato, nti naye waliwo ebintu ebirala ebyamuleetera okunoonyereza ku bintu ebyo.
You have also interpreted the factors. Those factors he did not disclose them to the court.
Nti ebintu ebirala ebyamuleetera okunoonyereza ku bintu ebyo teyabibuulira kooti.
The accused person further stated that he was under the control of some people whom he occasionally referred to as friends and were in three categories.
Nti yagamba nti yali akola olw'ensonga y'abantu be yali ayita mikwano gye ate nga baali bangeri busatu.
He also alluded to the fact that between January 2026 and March 2026, he entered into a distressing period because he was contending with some people who were surveilling him, making demands from him, and they threatened to kill him.
Nti yagamba nti wakati w'omwezi gwa January n'ogwokusatu 2026 yali mwenyamuvu nnyo olw'abantu be yali abaali bamusumbuwa era nga agamba abaali bamutambulirako era kyekyamuviirako okukola ebintu bino.
According to him, they began demanding for money, and he noticed that they had all the capabilities and they were following him closely. And as a result, he left the neighborhood of Bunga where he was staying and resorted to sleeping on the streets.
Nti baali bamusaba ssente era nga yalaba nga baali balina obusobozi nga bamugoberera nnyo, kyekyamuleetera kuva Bunga gye yali abeera n'agenda n'atandika kubeera ku luguudo.
The accused person stated that as a result of this, he tried to end it some way and somehow, so as to bring the whole thing to an end. And according to him, he tried to flee the country, tried to rob a bank, and tried to kill his brother's family. He then said that those people whom he at times referred to as his friends during his testimony had something to do with his actions, of 2nd April 2026.
nti yatuuka ekiseera n'ayagala kikomenkereza n'asalawo ave mu ggwanga n'agezaako okubba banka n'agezaako okutta famire ya muganda we n'agamba nti abantu abo be baali balina kye balina ku kyatuukawo nga 2 Ogwokuna 2026.
He invited the court not to honor the charges of murder because there were some circumstances that forced him to act the way he did on 2nd of April.
N'asaba kooti ereme okumusingisa omusango gw'obutemu ng'agamba waliwo ensonga ezamuleetera okukola bye yakola nga 2 Ogwokuna 2026.
Unfortunately, he neither stated the circumstances he claimed forced him to act that way, nor did he disclose the identities of his friends who may have compelled his actions on 2nd April 2026.
Ntebyembi teyayogera biki ebyamuleetera okukola ebintu ebyo bye yakola nga 2 Ogwokuna 2026.
No, he did not state the circumstances, and he also did not disclose the identities of those friends of his.
Nti ebintu ebyo ebyamuleetera okukola bye yakola ate n'amanya oba okwogera baani abamuleetera okukola ebyo bye yakola 2 Ogwokuna 2026 teyabyogera eri kooti.
And because he made an unsworn statement in his defense, he could not be probed to give more information.
Olw'ensonga nti teyalayira ng'awa obujulizi baali tebasobola kumubuuza ebibuuzo bingi ku kino.
By the above claim, the accused raised a defense of insanity.
Olw'ekyo yagamba nti ye omutwe gwe gwali tegukola bulungi mu kaseera ako.
The defense of insanity is provided for under Section 11 of the Penal Code Act, Chapter 128.
Nti ekyokugamba nti omuntu omutwe guba tegukola bulungi ekitabo kya bibonerezo kikyogerako mu kawayiro ka 11.
And this is what it provides: that a person is not criminally responsible for an act or omission if at the time of doing the act or making the omission he or she is through any disease affecting his or her mind incapable of understanding what he or she is doing, or knowing that he or she ought not to do the act or omission, although his or her mind is affected by disease, if that disease does not in fact produce upon his or her mind one or other of the effects mentioned in this section in reference to that act or omission. I will summarize this to mean that the accused, somebody must show that